All right, brings us to our second case, Eva Marie CARON versus Enterprise Leasing.
May it please the Court. My name is Robert Telfer. I'm appearing on behalf of the appellant Eva Marie CARON. I would request the Court reserve me 5 minutes at the close of argument for rebuttal. Before I begin, as to point 3, I want to point out an error in my brief and withdraw an argument. That is the point concerning the applicability of a set-off for the cost of PIP. In the brief, I argued that since 768 was later enacted than 627, it would take precedence. In fact, under that statute, at the very beginning of it, it says if it is in conflict with another statute, that the other statute takes precedence. I withdraw that argument. It was my mistake, and I apologize to the Court.
Thank you, counsel. We'll note that.
With respect to this appeal, there are 3 points raised. One has to do with the jury that was seated and the refusal to grant peremptory challenges. The other is whether a directed verdict should have been entered.
Peremptory or challenges for cause?
Challenges for cause, excuse me. Challenges for cause. And the third is the interaction between the two statutes where we claim that we ought to be allowed a set-off for the cost of PIP under the insurance policy as against the judgment that was entered. With respect to the first point, I want to concede, and have to concede, that under Trotter v. State, I didn't specifically, by name, identify the jurors that I wanted to challenge for cause. But I take the position that under the circumstances in which this occurred, that we still preserved the issue for appeal here. What occurred, and I've cited in my brief several of the jurors that I felt should have been excused for cause. But when it came time to seat the jury, and I asked for the peremptory challenges, I asked for 2 peremptory challenges. The Court immediately said defense. They immediately said this is preposterous. And the denial for peremptory challenges was basically said even before I had the chance to specifically identify. But following up to that, when I was further asked, or I maintained my objections to the juries that were seated, I based them specifically on, Your Honor, I object because of the jurors that were seated that were objected to because of cause. And I believe under the Live Oak v. Townsend case, I met the standard to preserve for appellate review. In that case, there were 8 prospective jurors, all of whom should have been excused. 4 of them were excused by peremptory challenge, and 4 others should have been excused and weren't. And the counsel in that case objected, saying that he wanted to excuse, that the other jurors should have been excused for cause. And the Court felt that that was sufficient to preserve the matter for appeal and for appellate purposes. With respect to that, the case law is also clear that forcing me to use peremptory challenges on jurors that should have been excused for cause is impermissible as well. And the question becomes, were any of these jurors rehabilitated to satisfy whether or not beyond a reasonable, whether there was a reasonable doubt as to their impartiality? And I suggest no. The first being Mr. Adavasio, the State Farm Adjuster, who twice...
Before you get into that, yes. Accepting your argument that there was no waiver, would you still have to, I guess, convince us that at least 2 of those 3 should have been excused?
Yes, absolutely.
You agree if there's only 1,
If it's only one, I've got a problem.
Okay.
I think all three of them could have been excused. Had I had the choice, Raffinello and Carlson would have been excused. I think Marcinic would have probably been my weakest argument before this court, frankly. And those two jurors clearly said that they could not or would not award for pain and suffering. Mr. Raffinello said, my hand doesn't work, my back has a problem, I just work around it, and I don't think you should be given money for that. He also believed that there were a cap on damages.
Well, and let's assume that someone says that. This case didn't involve a cap. There was no issue of a cap. And so you start asking jurors their feelings about caps. Well, you could have asked these jurors their feelings about the death penalty, and that wouldn't have been terribly relevant to the case either. Now, caps might give you some background for your decision to peremptorily challenge a juror, but why would that be a basis for a challenge for cause?
Other courts have...
It wasn't an issue in this case.
Right. Well, two things. First, I think we had already in voir dire expressed the opinion this was going to be very substantial damages. And that is, of course, what we sought at the trial level based on the injuries that we alleged took place. So someone having a cap or a belief that there shouldn't be a amount greater regardless would certainly apply. And there is...
But these people aren't saying that the cap ought to be, $5 or $100 or $1,000. They're saying, I have no idea.
Right.
Everyone's going to have a limit. If you were to extend the logic of that argument, well, what about $1 trillion? Right. What about $100 trillion? You can extend that logic indefinitely, and so I'm failing to understand someone who says, well, at some point, there's going to be a cap, but I can't tell you what that cap would be. How that's a challenge for cause?
Well, I think it impacts their ability to fairly and impartially set an amount of money that might be appropriate in the case.
And where in the record do these jurors say that?
Most of them say, I can't tell you what the cap's going to be, frankly.
And so you think from that answer that says that they can't fairly apprise the value of pain and suffering?
Well, if you're taking it totally in the abstract, it may be true, although that was a disqualifying situation in the Rodriguez versus Langio Messino case that I cite in the brief out of the 3rd District in 2006, where a juror, Mr. Hilberry, was excused because of his statement about caps on damages and was not rehabilitated on it. I think in this case, you take the caps on damages in conjunction with what the jurors were saying, particularly Chandler and Raffinello, that you don't give for pain and suffering as well. That I just work around it. Chandler was even more specific that she didn't believe in it. And to say that these jurors can give those opinions...
Chandler is the one that said that she thought a person's outlook on life...
It's your outlook on life. Pain and suffering isn't going to help you. It's not going to be of benefit to you. It's how you look at life. And certainly, those views...
well, she said she would award damages she believed were just and fair.
Right. Later, under questioning.
Or whatever.
We get
the fact
into
that it's later doesn't make that much difference.
Well, we get into
as long as she can follow the judge's instructions on what pain and suffering damages are, I'm having a problem seeing where the problem is with her.
If you're wavering, it was like Mr. Adavasio and the others. If in one aspect you're saying, no, I'm not going to get, pain and suffering doesn't do you any good.
No. What they're saying is that it's a bad idea as a social policy to give money for pain and suffering, but if the judge tells me that's what I'm supposed to do, that's what I'm going to do. That's fairly well what these guys said.
I believe with Chandler that she, and excuse me, and I don't want to mislead, I think in my brief I said she wasn't specifically rehabilitated on that point. The questions that were asked about that, and basically the Chandler was then about whether you can be fair, you can award money or whatever, And they ask if you feel that his client proved his case for damages, you think that you would do what you think is fair and just in awarding damages.
Isn't that what jurors are supposed to do?
Well, if I think that pain and suffering isn't part of it, or if I think an important part of the damages isn't part of the equation, I'll be fair and just and give them all their economic damages. I'll be fair and just and give them all their lost wages.
But
I'll be fair and
Chandler
just and not
didn't
give
say
them
she
fair.
wouldn't award damages for pain and suffering. She didn't say that. All she said is that your outlook on life is important on your ultimate outcome when you suffer pain and suffering.
I understand, but she said a little more than that. She
I'm
said,
just saying that since to receive something for what happened to you, but I'm saying that it has to do with how you think of things. But I would agree with that a little bit.
she also said pain and suffering money isn't going to help.
Well,
And therefore, you should just have a better outlook on things. So if it isn't going to help, I suggest she's going to be reluctant to give it, and she isn't going to give it in a fair and just amount. And she was not specifically rehabilitated on that.
Who do you think was the worst?
Raffanello, out of the three that were seated, was the worst.
Raffanello. Okay.
As to the others, having to waste the preemptory challenges to get there, I think it's clear. Ms. Redditch said she didn't believe in awarding pain and suffering damages. That belief wasn't going to change in the next few days.
Raffanello was, the issue with Raffanello was the caps, correct?
Caps and pain and suffering, because he also said, if I have something wrong with my hand or something with pain and suffering, if I have a problem with my hand or a problem with my back, I just work around it. I don't think that's something you should be compensated for. And that was his statement. So
He said that he thought pain and suffering damages should be awarded if sufficiently proven. However, he indicated that compensation should not be given if a person cannot do something because of a back or hand.
right. And here we had a case with herniated discs, and we alleged herniated discs in the neck and the back, as well as significant brain injury. And he's telling me, well, if you got a problem with your back, you just work around it. You got a problem with your hand, you work around it. I don't believe you get awarded money for that. And I don't see where that can be cured, or that doesn't leave a reasonable doubt in a person's mind as to a juror's fairness. I'd like to move on for a moment to the enterprise one, which I think is... I'm well aware of the long list of cases that say that this is ordinarily a matter for the jury in rent-a-car cases, but in this particular case, I believe there was no evidence upon which a judge could submit to the jury that a conversion or a theft of this car had occurred as to enterprise. And I make that distinction as between enterprise and mom. Mom signed the contract. Enterprise divested itself of possession of the vehicle, and in doing so, left itself open under Florida's Dangerous Instrumentality Act to the use of the vehicle beyond its consent. One interesting thing, and I had to take a magnifying glass to my copy of this contract. The contract itself is interesting. In paragraph 14 on the second page, states, above it states it's a violation of this contract if someone else uses the car. It's a violation of this contract, etc., that mom signed, not the girl. But the next paragraph says, if after a violation occurs, you continue to use this car, then it's a misuse without our permission, without our consent, and we can report the car as stolen. And that's the contract, which is kind of interesting. It's a little different than the contracts I've seen before. So, although it may have been a violation for this girl to use the car, the violation was between her and mom. In the Ming case, which was argued at court, where...
Well, hold on for a second.
Yeah.
The contract said that only the signatory drivers were permitted to drive the car, nobody else.
Correct.
And besides that, young people weren't permitted to drive the car anyway. I think it was under 25 or something. Is the daughter under 25?
Yeah, she was under 25. She was 17. She had just gotten her license. She was a...
See, the issue of whether it was a stolen car or not, though, is not a contract issue. That's a criminal law issue. So I'm not so sure the contract itself has a great impact on that. How do you view that?
And where we come to that is the girl herself testified that she had no intent to steal the car. The mother testified that the girl simply borrowed the car, albeit...
But the girl acknowledged that she had no right to drive the car, and the mother acknowledged that the daughter wasn't supposed to be driving the car, and it was without her permission, without her knowledge, without her consent. Isn't that a question for the jury then to determine?
Well, it is if mom's involved, because in the Ming case, which is a little different, the mother had actually pled conversion in that case. In our case, the mother said, I don't think she stole it. I don't think she converted it. She just borrowed it from me. And yes, we had this rule with family cars, although the rental car was never discussed, although I left the keys on the dresser there in the room. And this is an emergent situation. You know, I can't see how you can elevate a 17-year-old girl having a biological problem that she considers to be an emergent situation, driving this car for a matter of...
The requirement to obtain feminine hygiene items is an emergency situation?
That's how she viewed it. That's how she viewed it. And, you know, they want to elevate this to grand theft auto. I just don't think it comes to that. There's no intent to steal. There's no intent to deprive the rent-a-car of possession because they didn't have possession in the first place, already contracted away. Finally, and I realize I'm running in, but I do have to address this. The PIP set-off obviously is crucial to us in terms of cost. As I set out in my brief, I don't see any good reason why this court cannot apply 768 to this situation. Clearly, that statute identifies as a collateral source automobile insurance that provides medical or lost wages. That's PIP. They argue that 627 doesn't apply. That statute is silent. They can be read together. There's nothing in that other statute that conflicts with 768. And so that, you know, it being the later expression of legislative intent and being able to be read together, we ought to get it. In the McKenna case, you did that where there was an offer of judgment involved to find the net judgment. You allowed the set-off for the cost of the PIP, for attorney's fees. There's simply really, it's a distinction without a difference to allow it here. In addition, had my client had medical insurance or disability insurance outside of that, they would have gotten a set-off for that too, and we would have been entitled to a reduction for the premium paid. There's simply no good reason to draw this distinction, and in fairness and equity, we ought to be allowed it. I thank you for your attention.
You have 3:16 remaining.
Good morning, Your Honors. May it please the Court, my name is Esther Galicia, and I'm with the firm of Fowler White Burnett, and we represent Enterprise Leasing. My co-counsel, Mr. Ebbett, represents Ms. Gannon, and we have decided to split our time so that I have 15 minutes and Mr. Ebbett has 5 minutes. And I will address arguments 1 and 2 that were raised by the appellant. First, with regard to the for-cause challenges and the preservation of error, counsel has conceded that he clearly did not comply with the Trotter requirements of specifically identifying 2 jurors that he would have stricken with the additional peremptory challenges if they had been given. Counsel nevertheless relies on the Live Oak versus Townsend decision, and it is our position that that case does not apply to this situation that we have here and does not basically excuse the failure to specifically identify 2 jurors that would have been stricken. In Live Oak, counsel in that case
Well, let's think about that for a second. There were 3 available to strike. He didn't he asked for 2 preempts, and he didn't identify which 2 he was going to use it on. Do you agree that if he can identify 2 of the 3 who whose challenges should have been granted, that's going to be sufficient?
No. Respectfully, the case law indicates that he needed to do it at the time of trial, not a year later at oral argument before the court on appeal.
Did he do it at trial when he did challenges for cause for 3?
Yes. Yes.
And then he told the judge afterwards, I think these three should have been the ones I challenged for cause. I object to them being on the jury.
He didn't say that, Your Honor. All he said, respectfully, all he said in the transcript, as recorded in the transcript, was that he objected to the composition of the jury. He did not say, I object to those three jurors who I challenged for cause and I did not strike peremptorily and who are still on this panel. I object to those three jurors sitting on this panel. He did not do that. If he had done that, we would not be arguing this point. But he didn't do that. And the case law in the Supreme Court in the case of Petrie versus State specifically said that even though your denials or your challenges for cause are denied, you still, when you ask for additional peremptories down the road, you need to identify those that you're going to strike, whether they're those that you've already tried to excuse for cause or any others. You need to specifically identify them, and he didn't do that. This district, in the case of Aragon, has applied that principle and clearly indicated that one of the requirements for preservation of error when there's a cause challenge denied is the specific identification of the jurors that you would have stricken if you had been given the additional peremptories, and he didn't do that. So it is our position that this issue was not preserved for this court's review.
If we believe that it was properly preserved, do you agree that there were challenges for cause that should have been granted that were not?
No, respectfully.
Okay, so you think that the State Farm agent should have been, that was an improper challenge for cause? Well, explain that to me.
Certainly. Mr. Adavazio was a State Farm agent who would refer his insurance clients to rental car companies when they were in an accident and needed the use of a rental vehicle. He referred them many times to Enterprise. Other times he referred them to Hertz or other rental car companies. But he never indicated in his questioning or his answers to the questions that he had a relationship with Enterprise that was of such a nature and such an extent that he would not be able to be fair and impartial.
Well, didn't he indicate that perhaps rendering a large verdict might affect his business relationship with Enterprise?
He may have suggested...
So isn't the potential financial incentive for a juror a classic case to grant a challenge for cause?
There would be, but in this case, Your Honor, there's no evidence to suggest, for example, that Mr. Adavazio was receiving money from Enterprise for each referral.
Didn't he say that it could affect, a large verdict might affect his business relationship with Enterprise?
He did, in a hypothetical, but he subsequently, on further questioning from defense counsel, indicated that he would not allow his relationship with Enterprise to affect his decision in this case.
That is, should a court accept that? If a juror says, I may have a financial interest in the outcome, but I can be fair, you're telling me that's not a basis for a for-cause challenge?
He didn't say he had a financial interest in the
outcome. He said there was the potential, depending on the size of the verdict. If it's a large enough verdict, it might affect his business relationship.
Sure, certainly, because if Enterprise went under, then that meant he would have no business relationship with Enterprise. But that isn't what this case is.
Or if they got mad at him for coming back with a large verdict.
Well, that would be Enterprise biting its nose to spite its face.
Isn't the case law replete with examples where just because a juror says they can be fair and impartial, that doesn't end the inquiry and the judge still has discretion and should grant a challenge for cause under certain circumstances?
Well, in this, respectfully speaking of the standard of review, yes, the judge has broad and great discretion, and it is only manifest error which justifies a reversal. And in this case, the case law clearly requires the panel to defer to the trial court, who is in the best position to assess.
Mr. Adavazio is asked, if you were sitting where we're sitting, would you want you on a jury? Mr. Adavazio says, I would be concerned, I think. Mr. Telfair says, about being able to be fair, and he says yes.
Yes.
You don't think that's enough to get him off that jury?
Let me respond to that.
Okay.
When Mr. Dill, defense counsel for Enterprise, questioned Mr. Adavasio about that. He said, Mr. Telfer asked you a question about if you're sitting at this table, would you want you to be on the jury? I think something along those lines. Do you feel you can be fair and impartial after hearing the facts and the evidence in this case and the judge instructs you on the law? Do you feel you will be able to follow the law as instructed by the judge? Mr. Adavasio said, I can follow the law as instructed. Yes. Mr. Dill then asked, do you feel you can be fair? I believe I could be fair and impartial. So it is our position that he was rehabilitated by this line of
Giving an
questioning.
equivocal answer about being fair and impartial?
Well, no, but he said he
I
could...
believe I can be fair and impartial.
I'll certainly try to be fair and impartial.
Excuse me, Your Honor?
I'll certainly try to be fair and impartial.
Well,
Let me ask you this.
Yes.
If a juror, here he indicates a possible financial interest, but if a juror says, yes, I have a financial interest in the outcome of this case, but I can be fair and impartial, should challenge for cause, is it required to be granted? Even though he says I can be fair and impartial?
I think that at that point it's a discretionary call on the judge's part, who is there listening to the questions, listening to the answers, looking at the jurors and their demeanor.
He has to believe beyond a reasonable doubt that the juror could be fair and impartial, correct? Isn't that the standard?
Yes.
And you think that series of questions is beyond a reasonable doubt?
Well, Your Honor, I wasn't there. Respectfully, Your Honors weren't there. I mean, reading the cold record is one thing. Being there in front of a jury, listening to the questions, listening to the answer, looking at them, look at their facial expressions, their body language, that makes the difference, and I
All right. The other jurors, it seems that the caps and the pain and suffering questions are the main point of contention. What's your position?
Well, our position on that also, Your Honor, is with regard to defense counsel's questioning of the jurors. Mr. Dill asked the jurors with regard to that specific issue. He said, excuse me, it wasn't Mr. Dill, it was Mr. Ebbets. He said, I'll be short with you. It does not matter whether you think that there's runaway verdicts or there should be caps on damages or shouldn't be caps on damages, as long as you agree with this, that you'll leave your personal philosophies about how you feel about things out of the courtroom and out of the jury room and only decide the case based on the law that the judge will give you at the end of the case. Everybody agreed with that position. None of the prospective jurors at that juncture indicated that they disagreed or that they had an objection to basically setting aside their personal views, whatever they may be, and basing their verdict on the evidence presented and the law instructed by the judge. So the case law we submit is replete with decisions supporting the judge's denial of the cause challenge in this case based upon the representation of all of these jurors. And that's the test for competency. I mean, we all have views, we all have personal opinions. Some of us are against the death penalty, some of us are for it, some of us are pro-choice, some of us are pro-life. But the bottom line is, can we, when we're sitting there in the jury room, set aside those personal views and rule on the case based on the evidence presented and the law that the judge instructs us on? And that's a test for juror competency. And in this case, all of these jurors said they could do that. So in light of that affirmation, it is our position that the judge acted within his discretion in denying the challenges for cause.
So a juror who says that I have bias, I have some bias, that as long as someone asks a general question, but you could follow the judge's instructions, that's it. That's good enough. That'll overcome the prior statement that I have a bias in this case.
Your Honor, the cases that I cited in my brief, which include the Monte Cristo case, the Fazzolari case, the Martinez case, and the Link case, all involved cases where the jurors had biases against the legal system, medical malpractice claims, and things of caps. And on further questioning by defense counsel, it was elicited that they could set those views aside and decide the case based on the facts and the evidence and the law, and that was deemed sufficient to support the denial of the for-cause challenge. And we, based upon what I've just read to you, submit that that was sufficient to deny the challenges for cause.
Does the juror have to go a little further and say, I can set aside any biases or prejudice, in addition to saying I can follow the law as instructed?
Well, the jurors were asked if they could set their views aside and follow the law based on the evidence presented, and they said yes. Was there a specific declaration from each individual juror with regard to this particular point or any other point or any other philosophy? No, but they all, as a group, agreed to set aside their biases and decide the case based on the facts and the law. And we submit that was sufficient to deny the challenges for cause. If I could switch gears
before you leave, and I just one quick. If you have a juror who has expressed some of these types of issues, a bias issue or economic impact, don't you think that the best cause of action, the best way to approach that is to actually talk to them individually? When you know that you have specific issues with specific jurors, you're going to rely upon a general question to the jury that the court reporter can't possibly know who's answering what. If you got 22 or 25 people sitting in the rows of seats and they ask a general question, can all of you set aside any biases that you might have? And some might answer, some might not answer. Don't you think the better approach would have been to have discussed individually with the jurors that had issues, whether they could set aside the problems that they've expressed?
In a perfect world, yes, and if we had an unlimited amount of time, I guess that would be the way to best handle it. But I wasn't trial counsel, but from my reading of the transcript, it appears as though once defense counsel was up there, there was a bit of a time crunch situation. And in fact, when Mr. Ebbets did his questioning, he basically addressed the panel that was there as a group because of whatever the time constraints were. But nevertheless, these individual jurors could have raised their hand and said, no, I can't set aside my personal views, if they were as strongly held as plaintiff's counsel says they were. But none of them did that, and in light of that, we submit that it was appropriate.
All right, well, let's go to the second issue.
Thank you. And is this 5 minutes for me or 5 minutes for the whole side? Very, very briefly, Your Honor, with regard to the theft and conversion issue, the trial judge refused to act as a seventh juror in this case. With regard to that issue, respectfully, I request that Your Honors refuse or decline to act as a seventh, eighth, and ninth jurors in this case. The issue of whether there has been a theft or conversion is clear in the law to be a question of fact for the jury. The facts in this case certainly raised a jury question as to whether Ms. Ganano used this vehicle for her own personal use and basically appropriated the vehicle for her own personal use, which falls within the definition of a theft. She did not have her mother's permission. She certainly did not have Enterprise's permission because she was a minor and wasn't an authorized driver. And the case law is clear. I cited to a decision out of the 4th District called Barnett, where when obviously the owner did not give the driver permission and then the lessee did not give the driver permission either. In that situation, the court refuses to impose vicarious liability on the owner and finds that the lack of consent, in this case by the lessee or bailee, is enough to establish the requisite theft or conversion and absolve the owner of the vehicle of any vicarious liability based upon...
All right. I think that you've handled that fairly well in your brief. Why don't we...
Yes. Thank you, Your Honor.
How much time do I have, Your Honor?
3 minutes and 45 seconds.
I'm sorry, Judge?
3:45.
45. I'll speak quickly and succinctly.
Be the first time.
Good morning. My name is Chobi Ebbets.
Pretend you're on Vorgire.
May I speak to the group as a panel? I want to speak, though, in 1 minute. Let me use 3 minutes. Let me speak in 1 minute to the voir dire issue as an officer of the court and as someone looking back on this case and having been a trial lawyer at the trial. If the court had asked me which of the jurors would I have had the most problems with from reflecting on the record, I would say it would be Al DeBasio. I just, looking back on the record, it really looks that way. But the trial judge gets the ping pong going back and forth. The last thing Judge Silvernair heard was this man saying and affirming to me that he would follow the law and put aside his personal proclivities. However, I will concede that looking back on the record, he looks like a person that a judge could have gone back to, asked some questions of, and said, I think we need to let him go for cause. But the court also asked my esteemed colleague, Mr. Telfer, how many of these do we have to have before we have a problem here? We need 2. I would respectfully submit the rest of those jurors were basically walking into a problem when Mr. Telfer creates his own problem by saying, you know, my own mother doesn't believe in pain and suffering. How do you all feel? And that you'll see is in the record. And when you start going in that direction, you get people with all kinds of personal stuff throwing out beliefs and philosophies. And I think that the others are philosophical points which were cured by these jurors saying they would put those things aside and follow the law. So I think we have 1 problematic juror, not 2, and therefore I still think that point stands in favor of the appellees.
So do you think Judge Silvernail erred in not granting the challenge?
I think that if he looked back at the record and he was sitting where you all were sitting, he'd probably say Al DeBasio shouldn't have been on the jury. I just, you know, I look at it. But at the same time, I know that he sat listening to the repartee going back and forth, and there should be a system. I have very little time here. There should be a system where when we have a cause instruction, it should be identified before we go to the final impaneling, and the judge ought to have the last say on that. Okay, we've raised cause. Let me ask some questions to this juror so the court's satisfied. I think
How
we
about
could improve.
Pinkerton, who said that that juror would have some bias?
I think if the judge believes, remember, it's the judge's beyond to the exclusion of every duty. If there's any reasonable doubt as to bias, the judge should excuse him for cause. That's the law. And the judge listened to both sides, and after he heard the repartee back and forth, he said no. I think if Judge Silvernail looked at this record, he'd say, well, kind of looking at what was said first, I'm not sure it was cured later, but that's in hindsight. As he was sitting there, he heard what he heard and denied the motion for cause. But I'm conceding.
Can you address the set-off issue?
I'm conceding that person is a problem. You know, I look at it. And
On the set-off issue, Mr. Telfer ended with a rhetorical question, why should we treat it different as far as the premium payment?
Real simple. It's a judgment. He was a prevailing party. He's looking to get costs as a prevailing party. You recover a judgment. Let me kind of boil that down in 30 seconds. You recover a judgment for the items of damages allowed by Florida law, medical bills, pain and suffering, loss of earnings in the past and the future, the elements of damage that are set forth in our jury instruction. That's a judgment. And interestingly, what he's arguing is, well, I really want a judgment for $110. I want a judgment for the amount that my client paid for the PIP that she secured, and that's what the record was, $110. And if I get that $110 somehow into the formula, I will recover thousands of dollars in costs for otherwise prosecuting this case. That's just illogical. And that's why your court is the court that decided the case that he cited, McKenna. It was your judge, Judge Cobb, that used, and I use this in my brief, the interesting language. We first have to look to 627-7363. The Supreme Court said that's what we follow. You all cited that correctly in McKenna. We follow that for the PIP issues, and it's because it's an automobile case, and we are specifically instructed what to do in an automobile case. I have 17 seconds. Judge Cobb said...
We're actually over 17.
I'm sorry. Judge Cobb said the only reason we're going to this other issue is 769-78. That was an offer of judgment case. That's what McKenna was, implicated the other statute, and by implicating the other statute, we'll go look at these questions of deducting the cost of the premium. But that's not what we do in an automobile case. It would be illogical to apply it in this case, and I've set that forth in my brief.
Thank you, counsel.
Thank you. I'm sorry I went over.
That's all right. We'll add another 45 seconds to your opponent's time. So you actually have 4 minutes left rather than 3:16.
Your Honor, first things first, there was I think counsel is mistaken that I didn't ask for, with respect to the challenges for the jurors for cause. I would point to the court, page 164 of the transcript. I don't have the record in front of me. But commencing at line 6, where the court asked, plaintiff ready for the jury. Mr. Telfer, yes, sir, I have to preserve my objections and things. I want to preserve my objection to the jury as constituted based on the challenges for cause that were denied. So it is specifically in the transcript, and the court can find it at that area. With respect to the Barnett case that they rely on for the second point, that case is distinguishable from this one. In the Barnett case, the people who had leased a car from Mercedes went to Mexico. While they were gone, their son was in school. 3 of his friends show up at their house when no one's at home, go into the garage, take the keys from a flower pot, and drive the car and have an accident. Everyone in that case, except Barnett, who was the estate of Barnett, acknowledged the car was taken clearly without permission. It was stolen. I think there's no doubt in that. Here in this case, the people that took the car in that case were not family members. There was not an emergent situation. There was, in our case, there's no claim by the parent that the car was stolen. It was only borrowed. No charges were pressed by Enterprise. No stolen car issue was raised to the police. There was no intent to keep this car, and it was being driven during the rental period when possession of the car had been given up. And the Susco case says it's a conversion or theft that deprives the owner of the incidents of ownership. And the incidents of ownership were never deprived to Enterprise. The car was voluntarily, for a price, placed outside their control. And certainly they might have had issues with Mom about the violation of the contract, but we're dealing with a 17-year-old juvenile who didn't know anything about the contract in the first place. With respect to the final issue, and that's the PIP set-off, and that's important. I think it's important for guidance throughout the state, frankly, in these situations. What just reason is there for not allowing a set-off for the amount of money that this lady paid for PIP under a contract?
Well, let me ask you this. You know, under the collateral source, if you pay for a disability policy, you pay for med pay, et cetera, the injured party is paying money, and the defendant is seeking all the benefits of that by having a set-off.
Yes, sir.
And so maybe it is reasonable to say, you know, if we're going to give the defendant the benefit, at least let's set off the premium because the plaintiff paid for that. But I guess what I want you to address is, you know, PIP is mandatory. If you want to own a car, you have to pay PIP. You also get a benefit that if you hit someone else but you don't cause permanent injury, you know, maybe you won't get sued on it. So, you know, it does seem to me there's different policy reasons.
Well, if you look at the collateral source statute that I quoted, it specifically defines as a collateral source automobile insurance that provides for medical payment and lost wages, which is exactly what PIP is. The other statute only provides for the way set-offs are addressed during trial.
But how should we construe the legislature's silence on the PIP statute versus their non-silence on the collateral source with regard to the offset for premium payments?
The PIP statute is silent as to offsets and
Right.
set-offs. It's not, and for that reason, the collateral source statute is more specific, and they're not in conflict. If that PIP statute had said you don't get a set-off for what you paid for that premium, I agree. It would be more specific. It would be in conflict with 768, and that PIP statute would apply. But here that wasn't the case, and the court found that in the McKenna case. There's no way you can allow that, I submit, in the McKenna case, when you're determining the right to attorney's fees, that you're going to take into consideration what the cost of PIP was, and then say, to arrive at the judgment, the net judgment, and then say, well, we're going to do that, but we're not going to apply it to costs. It just doesn't seem fair and reasonable. And the equities, again, are with us on this. All of the rest of
Counsel,
this
your time
was
has
their win.
expired.
Thank you, sir.